Here's a real property problem which is quite straightforward, even simple, but it's not easy. Take a look at the call of the question. 1. What right, if any, does Betty have to continue to use the road? Discuss. Clearly this is a question involving land use, almost certainly involving an easement, and we know that theories of easements are pretty straightforward. Typically, we've got either an easement by an express grant or a prescriptive easement. Once in a while, we might see an easement by necessity. Next, question 2. What right, if any, does Dot have against Cal based on the contract, the deed, or both? Discuss. This is an interesting call of the question, and it's actually quite specific. We know we're dealing with a civil lawsuit, Dot versus Cal. We know that she's got two theories of liability, one based on contract and the other based on a deed. Clearly, if she's a plaintiff alleging a contracts theory, she's got to be claiming that the defendant has breached a contract. Also, if she's got parallel theories relating to a deed, we know that the problems will arise out of a land sale contract, and typically the only way a deed could arise in this context would be if the plaintiff is alleging that the defendant has breached various warranties within the deed. Now, as it turns out, the resolution of this second call of the question really turns on a tiny and comparatively obscure part of the black-letter law, and there's no better way to learn that little piece of black-letter law than by making your way through this problem. So, let's go to the top of the question and see how the issues play out. In paragraph 1, we find out that Betty's first theory with regard to this easement is that she has an express grant of an easement. We see in paragraph 1, Al grants an express easement to Betty. It's a 30-foot easement, and we see, as is so typical on the part of people that receive express easements, she fails to record her easement. And as a result, everybody else may not be on the type of notice that they would be otherwise. Look also carefully at the extent to which she actually uses the easement. She's only using 20 feet out of a 30-foot grant. That implies that she's going to have a theory of possession based on adverse possession. And so, if her right to the easement is going to be grounded in adverse possession, she's only going to get to use that part of the easement that she actually is taking advantage of. 20 feet here rather than 30 feet. All right, so far this is a very straightforward question, and an uncomplicated one as well. So go to paragraph 2. Here we see Al quit claiming the property to Cal, and we see that the easement is not mentioned in the deed. So let's pause for a moment. We know that Al cannot convey to Cal any greater interest in the property than Al already has, and we know that Al's property has been burdened by this easement to Betty. So we see that Cal does not have actual notice of this easement, but certainly he would be on inquiry notice if he was to take a look at the property. Next, we see Cal engaging in a land sales contract with Dot, and we also see that Cal issues a warranty deed to Dot, and we see that the easement is not mentioned. Then we have Dot recording the deed, and then finally Dot blocks the easement, and that gives rise to the call of the question that we've already had a look at. Well, let's pause for a moment. This is a vastly simpler question than many real property essays, and also questions very much like this can appear on the multi-state bar exam. It's easy for the multi-state examiners to provide a comparatively long fact pattern and then ask a number of questions about it. So our principal problem with regard to answering this question, beyond knowing a little bit of law, is how can we best organize an answer to this question that will be fully responsive to the questions presented and that will allow us to carefully analyze all of the facts? This is not a racehorse question the way many are. This is a question that requires a certain degree of depth and careful consideration. So turn the page and take a look at the outline of issues that I present, and you'll see that with regard to the first call of the question, Betty's right to continue to use the road, the approach that I take is primarily a chronological one. I go through what happened in the order in which it happened in order to flesh out the various issues. Ultimately, however, Betty's theories involve an express grant and a prescriptive easement. Now, ultimately, I think Betty is likely to win under either one of her theories of liability. But what counts here, almost more than the answer, is the depth and breadth of your analysis. So we begin with the quitclaim deed from Al to Betty in 1950. There's nothing wrong with it, and there really aren't any issues about it. We're just put on notice that there is a deed and that Betty fails to record it. Next, we have to consider Al's conveyance to Cal. We know that the deed is silent as to the existence of the easement, so it's likely that Cal will not have actual notice. Also, because Betty failed to record this deed, it's impossible for Cal to be placed on constructive notice of the existence of the easement. However, he would be placed on inquiry notice. We know that buyers have a duty to inspect, and had Cal inspected this property, he would have observed this road present, and he would have inquired about it. So ultimately, I conclude that Al cannot convey to Cal anything more than Al already has. Since Al's property has been burdened by this easement, I find that Cal will be on inquiry notice of its presence, and I find ultimately that Al conveys to Cal, Cal is going to be subject to the easement. Next, we see Cal conveying to Dot, and here again the same issues of notice arise. We know that Dot is not under actual notice. We know that her study of the chain of title will reveal nothing to put her on constructive notice. However, once again, Dot, just like Cal, will be held to have inquiry notice. Had Dot inspected this property, she would have observed the road, and she would have obviously been inclined to inquire about what it's doing there, and whether or not some other party might have a right to use it. So, after going through all of this analysis, I find that Betty is likely to have title to this property just based on the conveyance. However, she's got a compelling adverse possession claim also, so I'd consider the prescriptive easement issue. And here again, the format that I'm using for organizing my thoughts is not the strict multi-elemental adverse possession structure, which obviously you're welcome to use. But I'm trying to focus your attention, and ultimately the reader's attention, on the substance of the analysis, not merely on remembering a bunch of buzzwords. Let's consider the adverse possession theory that Betty has got. Let's consider her mental element. Is she occupying this property with the requisite mental state? Answer, yes. She's occupying the property with under color of title. She has obtained a deed to this easement. She failed to record it, but that failure to record doesn't change her mental state. She is occupying this property believing that she has a lawful right to own it, and as a result, the mental elements, the hostility aspect of adverse possession, is satisfied. Well, how about the physical element? Here we have to get into the distinction between the amount of land granted by the express easement and the amount that she's actually using. The grant was 30 feet. She's actually using and maintaining 20 feet, and that's all she's going to obtain title to by adverse possession. So ultimately, I conclude that Betty will have the right to continue using the land that she actually is using for sure. Whether or not she'd be able to claim title to the other 10 feet is a somewhat narrower, actually a wider, a somewhat closer call. So finally, I conclude Betty does have the right to continue to use the road, at a minimum, the 20 feet that she actually is using. So now we consider Dot versus Cal, and here the entire lawsuit, all of our analysis, turns on one little detail of black letter law. And if you didn't know it before, you're going to know it after you review this essay. Let's consider the contracts analysis. Clearly, Dot and Cal had a real estate sales contract. We've got the key terms of that contract in the fact pattern that we looked at. But here's the key black letter law idea. Where we've got a land sales contract, the rights to sue under the contract terminate at the time the deal closes. So, although it is evident that Cal breached the land sales agreement by selling property that he didn't have entirely clear title to, the right to sue under that contract ends at the time of closing. And therefore, Dot has no rights against Cal with regard to the contract because she waited too long. But the deed analysis is going to give Dot a way to prevail against Cal. And here we see that Cal executed and delivered a warranty deed. Well, what's the laundry list of warranties? You'll know that the right to convey is a key one of those. Also the covenant of season and the covenant against encumbrances. There might be one or two others. The idea is to explain the relationship between the parties. The key black letter law is not all of the different line items of what the warranties are. The key black letter law idea is that Dot's rights under the contract ended at the time the contract closed. Now she has to sue based only on the deed. That's the key black letter law idea, and with regard to the various warranties, I think we can likely agree that the defendant breached all of them. So obviously the more you remember, the better. But pause for a moment. Look at how this material is being tested. What we really have to do is keep track of the relationship between the parties and explain what the rights of the parties are. And it is in that context that being able to remember the various warranties becomes useful. The bottom line here, the conclusion is Dot wins. Cal is going to be found to have violated the warranties in the deed, and so he's going to have to compensate Dot for the value of the easement. So at the end of the day, Betty has the right to use the road. Dot has the right to be compensated for the value of the easement, and Cal is the one that's going to be on the hook for that obligation. And that concludes an analysis of a straightforward and simple real property essay question. It's straightforward and simple, but it's not exactly easy. You've got to keep track of some fairly elaborate relationships, and you need to know a couple of obscure bits of black letter law.